my panel of experts think about how this would be applied in a case against James Comey. Joining me now, Senior Legal Affairs reporter for Politico, Josh Gerstein, CNN legal analyst Carrie Cordero, and former Assistant U.S. Attorney for the Eastern District of Virginia, Jean Rossi. Glad to have all of you here. I want to begin with you, Josh, because I need your eyes and ears. You were actually inside the courtroom. Take me there. What was Comey doing when this went down?
Well, he was already in the courtroom when the reporters were let in there about 15 minutes before it started. It was pretty somber, pretty quiet. He spoke with his attorneys a little bit. And when the judge came in, Comey stood up sort of ramrod straight and stared straight ahead in the courtroom. And that in and of itself is a bit of a scene because Comey's 6'8". And so standing next to his female defense counsel is substantially smaller. He sort of towered over everyone else in the courtroom. And then on the prosecution side, you had Lindsay Halligan, this very new U.S. attorney in Alexandria, who's former Trump lawyer, who really doesn't have a lot of experience. Some of the things that the prosecution did, even during this brief hearing, sort of gave me the feeling they're a little bit green. And
like what?
Well, things like they were very deferential to Pat Fitzgerald, Comey's defense attorney. You know, every time the judge asked a question, do you guys have an agreement on a schedule? Do you have an agreement on a discovery plan? Tyler Lemons, who was the AUSA, they brought up one of them from Raleigh, North Carolina, sort of deferred to Fitzgerald.
Which is usually the other way around.
I've never seen at the outset of a criminal case the prosecutor deferring to the defense, but Lemons was pretty candid in saying, we haven't really got our arms around all the paperwork, the records, the discovery that's relevant to this case, which is surprising in general in a criminal case, but not surprising in this case because we know Lindsay Halligan wasn't involved in it until a few weeks ago, and these other two prosecutors don't seem to have been involved until a couple of days ago. So there's no way they could be totally up to speed on all the details of the case that they need to be up to speed on to answer some of the judge's questions.
And by January 5th, a trial date, by the way, on this point. Let me ask you, Carrie, on this, because some of the paperwork they had to wrap their arms around includes some pretty serious previews of emotion. They're arguing that she wasn't appointed properly, the U.S. attorney. They're arguing that it was vindictive, it was selective, that it's outrageous government conduct, it's an abuse of a grand jury. Think about these motions. Will they be successful?
You know, I'm particularly interested in the allegation against the U.S. attorney, the acting U.S. attorney, not being legitimately in that position, because that particular motion that the defense is going to make enables them to make that argument irrespective of any of the facts of the case. So there's sort of going to be two separate tracks. One track that will evaluate the actual merits of the case, they'll have to get discovery, and then this separate motion that when you look at the statute governing acting U.S. attorneys, and it talks about the 120-day limit, they were beyond that limit with the prior acting U.S. attorney, and then the president just placed her into this role really for the purpose, I think we all know, of bringing this particular case. And so, you know, there's not in the statute governing that acting provision, there's not really a mechanism that it would be enforced unless you have a particular case that is unique like this, where she is the one who actually signed it. So any other case in the Eastern District of Virginia, you could have other AUSAs who sign the cases, and so it wouldn't necessarily be an issue that could be challenged. But this particular case, because she was the one, since nobody else in that district would sign this indictment and take it to the grand jury, this case ends up being the vehicle to challenge this other law. Which
probably will dovetail to the abuse of grand jury claims. They're thin on the details. We don't know what that's going to look like. But we do think the Wall Street Journal is reporting tonight, Jean, that post from President Trump on Truth Social, the one last month, saying that he wanted him indicted, and lo and behold, he was indicted. He's saying, ooh, that's supposed to be a private message. Is that going to change the way the defense team is going to try to use that to suggest it was vindictive? That there was somehow, that, as he said, President Trump is the one prosecuting this case?
I don't think it changes it at all. I did want to add this on the interim issue.
But wait, why doesn't it change it?
Because when you file a motion for vindictive prosecution, all the emails, potentially all the emails and memos and documents that show a malevolent motive, that's fair game. And whether it was a public post or a private post, it's the president's post to members of his cabinet or the Department of Justice.
And by the way, Pam Bondi yesterday in her hearing did not in any way try to flush that out and said that she wasn't going to talk about that. She was evasive, to say the least, when she wasn't being defiant on that point.
Okay, what I'd like to say, though, is Sam Alito is going to play a big role in the dismissal of this case. When he was Assistant Attorney General or in a high-level position in the 1980s, he wrote a memo saying that in every U.S. Attorney district, you only get one bite at the apple. You only get one interim U.S. Attorney. This is the second one. She signed, you brought up a very good point, her signature is the only one on this indictment. So if she has no legal authority to sign an indictment, then it's dismissed and they can't refile it. I did want to talk.
Well, hold on. I want to bring back to this point. You were in that courtroom when these issues were obviously raised. The judge is aware of all these things. Did the judge give any insight as to how they were considering this, or any questions about flushing anything out?
Well, the prosecution didn't say anything in response. I mean, Halligan was sitting right there in the middle of the prosecution table. But the judge did say that on this question of whether the U.S. attorney would be disqualified, which might lead to the whole case being thrown out, that he intends to send that issue to another judge. We've seen similar challenges to this, things like this the Trump administration has done in New Jersey, in Arizona, and in California. And in each of those cases, they've used a mechanism to sort of get the issue away from the judges that handle all the cases in that district that the U.S. attorney might bring, and send it to a judge from another district. Okay. And that's what Judge Nachmanoff said he plans to do here, ask the Fourth Circuit to reassign that issue, just that particular distinct motion, to another judge who doesn't sit in the Eastern District of
a legal hot potato. But what if that doesn't work and the case goes forward? Evaluate the merits of this claim.
Well, of which one?
The actual indictment against Comey.
The actual indictment?
Persuasive?
Well, as you all know, it is 2 counts, and it is very slim in terms of the facts that are actually in the indictment itself. So he's charged with making false statements, and he's charged with obstruction of Congress. And beyond that, it just references his September 30th, 2020 testimony, where he was giving virtual testimony before the Senate Judiciary Committee in a hearing. And beyond that, the persons who are referenced regarding the allegation made against him, that he authorized somebody to leak some piece of information to the news media, aren't identified. And as I understand it in the hearing, the defense counsel says they still don't know who some of these unnamed persons are. And so the defense has so much information that it still is owed by the government for it to even be able to put on a defense and for the government to show any of its cards in this case.
Judges don't like that. They want everything clear for the defense. Thank you, everyone, so much.